get the House Judiciary Committee to order. Will the Secretary please call the roll?
Chairman Briggs.
Here.
Representatives Abney.
Designation here.
Carroll.
Designation here.
Donahue. Hanbidge. Hohenstein. Howard. Kenyatta.
Designation.
Kincaid.
Designation online.
Mays.
Designation.
Pielli.
Designation.
Rabb.
Designation.
Sanchez. Schusterman. Chairman Kaufman.
Here.
Representatives Bonner. Borowitz.
Designation.
Ham.
Designation.
Kale.
Designation.
Kerwin. Clunk. Kuzma. Ledbetter. Pugh. Rigby. Shalaba.
Designation.
Mr. Chairman, a quorum is present.
Thank you. Having a quorum, we will proceed with today's agenda. First on the agenda, I will call up House Bill 603 by Representative Isaacson. The representative is at the Education Committee. She's on the Education Committee and sent her regards and appreciation for running it. Council, please provide a brief description of House Bill 603.
Thank you, Mr. Chairman. House Bill 603 by Representative Isaacson amends our whistleblower law to strengthen its protections by providing complainants with a right to a trial by jury, increasing the statute of limitations from 180 days to 2 years, and allowing for punitive damages. This bill takes effect in 90 days, and there are no amendments. Thank you, Mr. Chairman.
Thank you, Council. The question is, will the committee report the bill, House Bill 603? Are there any comments on the bill? Representative Bonner, you're in order on the bill. Wait off. Representative Bonner.
Thank you, Mr. Chairman. I have three concerns with this bill that hopefully can be addressed as it may move forward. The first, it does, for the first time, recognize the right of an injured party to request and have a jury trial. And I don't have any opposition to that particular request, although I do think it should be mutual, where also the defendant would have an equal right to request a jury trial. We do find that in our Constitution relative to criminal trials, that not only does the defendant have the right to a jury trial in a criminal proceeding, but so does the government. And since many of the whistleblower cases can and do involve governmental entities, I do think it should be a mutual right that either of the parties, the plaintiff or the defendant, should have the right to a jury trial. My second thought, punitive damages are seldom, if ever, allowed against a governmental entity. And many of the whistleblower claims involve actions against governmental entities. And in that regard, I do not believe that punitive damages should be allowed against a defendant which is a governmental entity. And in fact, it would conflict with the Sovereign Immunity Act, which does not permit such damages against a governmental entity. Thirdly, relative to the statute of limitations, I have no objection to it being extended from 180 days to 2 years. But for those other two reasons, I cannot support the bill at this time. So I appreciate the opportunity to make these remarks and look forward to the debate on this issue. Thank you,
Great.
Mr.
Any
Chairman.
other comments on the bill, House Bill 603? I support 603. It's a good bill. Secretary, please call the roll.
Chairman Briggs.
Yes.
Representatives Abney.
Designation, yes.
Carroll.
All Democrats will be yes.
Okay. Chairman Kaufman.
No.
Representatives Bonner. Borowitz.
Designation, no.
Ham.
No.
Kale.
No.
Kerwin. Clunk. Kuzma. Ledbetter. Pugh. Rigby. Shalaba.
No.
Mr. Chairman, this bill passes a vote of 14 to 12.
House Bill 603 passes and will be reported as committed. Thank you, Secretary. Next on the agenda, the chair will call up House Bill 713 by Representative Howard. Chair will recognize Representative Howard for brief remarks on her bill. Representative, a good member of the committee, you are in order.
Thank you, Chairman Briggs. So we did pass this anti-SLAPP bill, which became Act 72, 2024, but at the time, there was an exclusion in its protections, and that exclusion was disclosures about sexual abuse, which were not protected. This bill does one very simple thing: eliminate the exclusion and extend the full protection. Since I've been working on this issue, I've heard from many victim advocacy groups and women who have faced lawsuits after having spoken out about assaults. We are all aware of the extreme challenges victims face when they come forward to speak of their experiences. This is never an easy path to take, and we do not need to make this even more difficult by allowing the artificial barrier of themselves facing a lawsuit for having spoken out. I thank you for your support.
Thank you, Representative. Council, do you have anything to add on the bill?
Yes, Mr. Chairman, the bill takes effect in 90 days. There's one amendment.
Council, please provide a brief description on the Amendment 02412.
Mr. Chairman, Amendment 02412 removes the changes to the Declaration of Policy in Section 1 of the bill. It deletes changes to the definition protected public expression in Section 2 of the bill, and it adopts the only change, and if adopted, the only change that will be made to Act 72 of 2024 is the removal of the exclusion related to sexual abuse and sexual violence that is currently in statute.
Thank you. Thank you, Council. The question is, will the committee adopt this amendment? Are there any comments on the amendment? Chair recognizes Chairman Kaufman on the amendment.
Thank you, Mr. Chairman. Anti-SLAPP laws were designed to protect public participation and civil speech. They were not intended to govern personal, highly sensitive protective order proceedings. These proceedings are fundamentally different from ordinary civil litigation. They are often emergency, ex parte, and fast-moving, and are based on limited information and sworn allegations that have not yet been fully tested. By extending anti-SLAPP protections into this space, we risk shielding even materially false statements from civil accountability. And for those and other reasons, I'll be opposing the amendment in the bill today. Thank you.
Any other comments on the amendment? Seeing none, Secretary could call the roll on the amendment.
Chairman Briggs,
Yes.
Representatives Abney,
Designation, yes.
Carroll,
Designation, yes.
Donahue, Hanbidge, Hohenstein, Howard, Kenyatta,
Designation, yes.
Kincaid,
Online designation, yes.
Mays,
Designation, yes.
Pielli, Rab,
Designation, yes.
Sanchez, Schusterman, Chairman Kaufman,
No.
Representatives Bonner, Borowitz,
No.
Ham,
No.
Kale,
No.
Kerwin, Clunk, Kuzma, Ledbetter, Pugh, Rigby, Shalaba.
No.
Mr. Chairman, this amendment passes a vote of 14 to 12.
Thank you. Amendment passes, and the question recurs, will the committee report the bill as amended? Are there any comments on the bill as amended? So we passed the anti-SLAPP bill. Ryan, Leader Bizzaro, Representative Bizzaro, worked on it for many sessions. It was one of the things we were really proud in the majority to advance and actually get into law. It could have been done much sooner. This was something that wasn't addressed. I feel like it is an omission. I understand the sensitivity of the entire thing, but I am advancing and supporting Representative Howard's bill to include this and close this loophole. Secretary, please call the roll.
Chairman Briggs,
Yes.
Representatives Abney,
Designation, yes.
Carroll,
Designation, yes.
Donahue, Hanbidge, Hohenstein, Howard, Kenyatta,
Designation, yes.
Kincaid,
Designation, yes. Online.
Mays,
Designation, yes.
Pielli, Rab,
Designation, yes.
Sanchez, Schusterman, Chairman Kaufman,
No.
Representatives Bonner, Borowitz.
No.
Ham.
No.
Kale.
No.
Kerwin. Clunk. Kuzma. Ledbetter. Pugh. Rigby. Shalaba.
No.
Mr. Chairman, this bill passes a vote of 15 to 11.
Thank you. House Bill 713 passes and will be reported as amended. Congratulations, Representative Howard. Next on the agenda, we have, I will be calling up House Bill 1541 by Representative Hohenstein and Representative Brown. I will recognize both Representative Hohenstein and Brown for brief remarks. As Representative Hohenstein, who's a member of the committee, is speaking, if Representative Brown could join us at the main table. Representative Hohenstein, you're in order on the bill. You can go to the main table too if you want, but whatever you want, Vice Chair. Newly designated Vice Chairman of the Judiciary Committee. You're in order.
Thank you, Chairman Briggs, and thank you, Chairman Kaufman, and thank you to my co-prime, Representative Brown. What's fair is fair. No one should be liable to have to pay for somebody else's mistakes, and in Pennsylvania, it's important that we ensure construction contractors can do their jobs without being held liable for someone else's mistakes. HB 1541 allows responsible contractors to keep building homes, warehouses, and office spaces, and also makes clear that they will not be on the hook for mistakes and negligence of others. Now, this may seem like a simple concept, but in truth, it is extremely complicated. And I want to thank my co-prime, Rep. Marla Brown, and also fellow committee member, Representative Ledbetter, who will be proposing an agreed-to amendment on this bill. They have worked with me on this, and I will say bipartisanship lives and breathes in this building. So thank you, reps. I also want to thank the various stakeholders and the advocates who have worked on this bill for more than a decade. Our former colleagues in this chamber, Representative Mike Driscoll and Representative Todd Stevens, also in a bipartisan way, championed this bill before me and Rep. Brown. The National Electrical Contractors Association has long advocated for this needed reform, and they have been joined by engineering, insurance, and contracting organizations and unions. We've also worked with the trial attorneys and the insurance industry, specifically amending the bill in ways that they suggested. I'm disappointed that after all of that collaboration, we still have work to do, but what I will commit, and I committed to the chair, the minority chair, we will continue that work with those stakeholders that have expressed concerns with this bill. And the baseline issue here is this prohibition on certain indemnity clauses would only allow for a limited reform of indemnification in construction contracts. And it focuses on an indemnifying party only being responsible for the losses caused by their own negligence. And Pennsylvania is one of only 5 states that doesn't have a common sense anti-indemnity statute. So we're behind everyone else on this. And that limits our ability to enforce appropriate construction contracts. Neighboring states like Delaware, New York, and Ohio already have done so. And the lack of having an anti-indemnity statute does pose significant risk to contractors in our state. It means often that they get priced out of jobs because of very high insurance premiums. It means, again, sometimes they are held liable for things that they didn't do. And when we restrict a business's ability to do business, then that is something that we have to look at and correct, and that's what I believe this bill does. So we finally put this together, and we will continue to have work to do. And I think that we can do that, and I appreciate the majority chair for bringing this forward. I appreciate all of the work that my colleagues on the other side of the aisle have already done, and we will be calling on you all to continue to do so. But we will be able to get this done, and I appreciate an affirmative vote on this bill today.
Thank you, Representative Hohenstein, for those brief comments. No, just Representative Brown, you're in order to comment on the bill.
Thank you, Chairman, and I also appreciate you bringing this bill forward. I appreciate my co-prime, the good representative from Philadelphia, working so diligently on this with me. As he mentioned, an indemnification clause holds one party liable for damages, claims, losses, and expenses arising out of bodily injuries of persons, damage to property, or economic damage caused by or resulting from a different party's negligence. And this is important because today's indemnification clause seems to be customary in construction contracts. For many contractors, it does not accept, if they don't accept this contract with a provision in it like this, they miss out on the contract altogether. So these provisions shift the risk to parties that can't control it. The contract states that negligence of one party falls on a different party that had nothing to do with the incident. This creates an unfair and unrealistic liability exposure. These incidents can create a negative reputation affecting a contractor's business, even though there was nothing they could do to prevent it. I became particularly interested in this because of one of my constituents, a company by the name of Bruce and Marilees. They're a small electrical contractor in my district. They were hired as a subcontractor here at the Capital City Airport. They were installing, they had one of their men installing cans. They were marking for plane traffic. And a third-party aggregate contractor was working for the primary contractor, stay with me, and he ran him over. The way the law is written, neither the primary contract or the third party responsible for this horrible accident was had to deal with any liability. So my constituent, who had nothing to do with the situation, had to pay for this horrific incident. Construction works best when risk is assigned to the party best able to manage it. 45 other states have already enacted some form of anti-indemnity statute in construction contracts. And today we can start the process by helping Pennsylvania become number 46. I would appreciate a yes vote. Thank you.
Thank you very much. Council, do you have anything to add?
Mr. Chairman, the bill takes effect in 60 days, and there's one amendment.
Perfect. Council, please provide a brief description of the Ledbetter Amendment.
Mr. Chairman, A02398 is an agreed-to amendment that makes technical changes to the bill and provides clarity. Thank you, Mr. Chairman.
Thank you. The question is, will the committee adopt Amendment 02408? Representative Ledbetter, do you have anything to add, or just want us all to vote yes?
Thank you, Mr. Chair. I thank the good lady from Lawrence County and the good gentleman from Philadelphia County. As council indicated, this amendment is technical in nature and adds needed definitions to the language of the bill.
Thank you. Thank you very much, Representative. Chairman Kaufman on the amendment.
Thank you, Mr. Chairman. I don't want to belabor the meeting. In deference to my colleague, Representative Ledbetter, and my colleagues, Representative Hohenstein and Representative Brown, I'm going to support the amendment, and with their commitment to moving forward and working with stakeholders who have been recently coming forward, such as the Pennsylvania Builders and NFIB, to make sure that the language is fine-tuned so that everyone can be on board and move forward in a bipartisan manner. I'm going to support both the amendment and the bill as it moves out of committee today. Thank you, Mr. Chairman.
Thank you, Chairman. Are there any other comments on the amendment? Any negative votes on the amendment? Seeing none, if the Secretary could report it as being unanimously amended. I'll turn my page. The amendment passes. The question recurs, will the committee report the bill as amended? Are there any additional comments on the bill? Representative Bonner on the bill.
Thank you, Mr. Chairman. I have had an opportunity to be involved in these particular agreements and clauses throughout my legal career. And my only concern is I don't think the bill goes far enough. It is limited to contract situations, and I believe we should generally outlaw these provisions across the board. But your bill is a start. I have encountered these indemnification and hold harmless clauses in amusement parks, in transportation agreements, in sporting events, and many different walks of life where a party who would otherwise bear responsibility shifts it over to another party who has done no wrong. So if anything, I believe that this bill does not go far enough, and I look forward to talking with the sponsors of the bill to see if anything, we should outlaw these altogether, as opposed to giving this benefit and privilege to those in the construction trades. That this has no place in law. The party responsible for injury or damage should carry that responsibility. It would be a major change in the legal system of Pennsylvania, but I think it's one that's long overdue. I thank you for bringing it to our attention, and I believe your bill is a start, but we still have some ways to go with it, so thank you.
Any other comments on the bill?
If I may briefly, Chair.
Representative Hohenstein, you're in order.
Yeah, the representative comments, I appreciate them, and we will have that conversation, sir. Thank you.
And Representative, I know you will work hard on this and meet with all interested parties. You've been doing it for a long time. Unfortunately, some folks came to the conversation a little late. I think it was introduced in 10 plus years ago, and you introduced this version in June of last year, so it's been definitely out there for a while. You know, so some of our allies have worked really hard to get to neutral. I don't know if everyone's going to be able to be on board with this. So I appreciate the willingness to have those conversations, to listen to concerns, but it is also important to understand the sensitivity of this. Any negative votes on House Bill 1541? Secretary could please, seeing none, Secretary could please report it as a unanimous pass. It will be reported as amended. Congratulations, members, on a good bipartisan effort continuing. Next on the agenda, the chair will call up House Bill 2118 by Chair Hill Evans. If council could please provide a brief description of House Bill 2118.
Mr. Chairman, House Bill 2118 by Representative Hill Evans establishes the Museum Unclaimed Loan Property Act to institute uniform rules to govern the disposition of museum unclaimed loan property. The bill provides guidelines for museums' obligations to lenders, for record keeping, and lenders' obligations to termination of loans for unclaimed loan property, and return or disposition of unclaimed loan property. Other things that are addressed in the bill is property on loan to a museum will not forfeit to the state treasury. The bill does not apply to property in possession of the museum under the Native American Grave Protection and Repatriation Act, or property seized, confiscated, forced sale, or other involuntary means in Europe during the Nazi era between 1933 and 1945. A museum that acquires title to unclaimed loan property under this legislation passes good title to another person when transferring that property with the intent to pass title. And the last thing I'll bring up is, as of the effective date of this legislation, a museum would have a lien for expenses for the reasonable care of unclaimed loan property after the expiration date of the loan. Mr. Chairman, last session, this identical language was introduced by Senator Phillips Hill in the Senate as Senate Bill 228. That bill unanimously passed the Senate and unanimously passed the House State Government Committee. The session expired before anyone was able to take it up. Chair Hill Evans introduced it this session. This legislation is intended to codify what state museums already do. This just applies those same standards to private museums. Thank you, Mr. Chair. The bill takes effect in 60 days. There are no amendments.
Thank you, Council. The question is, will the committee report the bill, House Bill 2118? Are there any comments on the bill? Representative Bonner on the bill?
Thank you, Mr. Chairman. Certainly a pleasure to be here today and deal with strictly legal issues in our legislation, as opposed to oftentimes we deal with ideological issues. So it's a pleasure to look over these bills and offer suggestions. One suggestion I would have for this particular bill is that it limits the contact information to the person who actually makes the loan of the item to the museum. And I believe that it should be broadened to include several contact individuals. Much like when you go into a hospital or a doctor's office, they want to know other potential contact persons that they can reach out to if they can't reach you. So I do think that the bill could be improved by adding several additional contact persons in case they're unable to contact the person who made the actual loan. And I would suggest that that can occur as part of an amendment process at a later date. So thank you, Mr. Chairman, for the time.
Thank you, Representative. We made a note, and we'll talk to the prime sponsor of your comment. Any other comments on the bill, House Bill 2118? A lot of work has been put on this. I want to thank the Speaker for referring this bill to the Judiciary Committee this session. It's a good bill, and I'm confident to advance it. Any negative votes on House Bill 2118? Seeing none, if the Secretary could report it as unanimously passing it, House Bill 2118 passes and will be reported as committed. Thank you. Before we get to the next bill, I just want to share some reflections. This session, the Judiciary Committee continues to be the most active committee. I think after today, we're at like 109, maybe we'll be at 110 bills and resolutions move through the committee, mostly bills. We do take up some resolutions, but way more than any other committee. And what's interesting, the way I try to do my committee, our committee, is I try to talk to everyone about what interests them. And not Democrats or Republicans. When Republicans come to me, I take a look at their bill and I put it on the calendar if I think it is a good bill for Pennsylvania. We have moved more Republican bills out of this committee than all other committees have moved their bills, total bills, except for the Education Committee. We've moved over 30 bills out of our committee. A third of the bills in the 4 years I was the minority chair, I don't think we got to double digits over 4 years of Democratic bills. So I really think the committee does good work. Of course, we disagree, and that's to be expected. We vote, sometimes it's party lines, sometimes it's unanimous, and sometimes it's mixed. The bill that we just did with Representative Hohenstein is an example. I want every bill to be bipartisan, collaboration, working together. I don't want that bill to be viewed differently than the bill before it or the bill after it. It's that bill. It's a bill that we are going to debate. What happened in the Health Committee yesterday is disappointing to me. I was in the committee. Members of this committee voted against a bill that they all said, oh, we support this bill, but we're voting because it's politics. And we don't like the way you're all handling another bill, so we're going to punish it. When I left yesterday, I told my staff I was going to go over the Bonner bill. because I was pissed off that a member that I've been working with would vote against something that they said they supported because of purely a political agenda. So I'm going to tell my staff, we are going to consider it. Two wrongs don't make a right. I'm going to continue to run the Judiciary Committee based on the values of individual bills that come in front of us, on the value of what they do for the Commonwealth, what they do for, we are in the majority. I get to decide what bills make the agenda, and I will continue to do that. There will be more Democratic bills than Republican bills, and more of our values will be expressed. But I don't want to be we could go down the rabbit hole of punishing, you know, I was told everything we do is politics. Everything we do in this building is politics. I don't buy that. I think there's policy. I think there's collaboration and partnership. If we keep going down this road, we'll just stop having meetings, right? Like it's insane to run committees like that. It's disappointing. What I saw is personal. I know this happens all the time in other committees. Nothing that I thought would touch the Judiciary Committee, but it did. So with that, I'm going to call up the Bonner Bill, House Bill 2124. I will be voting for it, but I don't want to put my staff on the jam because I did tell them yesterday I was going to go over it. But Council, if you are prepared to go over, I'm recognizing Representative Bonner I will underline brief remarks on his bill. Representative Bonner.
Thank you, Mr. Chairman. I understand your remarks and appreciate the spirit in which they are made. So thank you. House Bill 2124 is a bill that is co-sponsored by the chairman, Chairman Briggs, and myself. This is a bill that has been adopted in 22 other states. It originates through the Uniform Law Commission, and they are a very outstanding, well-recognized group within the legal profession that has offered and authored many pieces of legislation throughout the United States. And in this particular legislation, they are offering for consideration a form of ownership and transfer of real estate, which allows for a quick movement of real estate, and it also allows for significant savings at the time of death of the original owner of the property. So how this particular legislation would work, an individual would have the right to have a deed drafted and signed and recorded at the courthouse where the property is located. And in that deed, the owner of the property can designate a certain beneficiary of that real estate, which title would then be transferred at the time of the death of the owner to that designated person. Now, the real advantage of this deed is that during the lifetime of the owner, he would have or she would have the right to revoke that deed at any point in time. So there's not a vested interest in the named beneficiary of that property in the deed. We don't have any form of ownership in Pennsylvania comparable to that, where an individual who owns real estate can designate a potential beneficiary of that property. And so the benefit of it is that it does allow the owner of the property during his or her lifetime to change the beneficiary on that deed. There's no vested interest in the named beneficiary. So it's simply drafting a new deed, recording it at the courthouse, and changing ownership. But the true benefit of it is at the death of the owner of that property, there are no probate proceedings that will be required to transfer the property. And probate proceedings can be costly. I would say typically in a probate estate, you're looking at around $1,000 to $1,500 in court costs and advertising fees. But frankly, the real charge in probate is with the attorney. So Chairman Briggs and I have both recognized that despite the fact we are attorneys, that the attorney's fee that would be generated in probate, which is typically between 3 to 5% of the value of the property, will not be incurred in this particular instance. So this is a very quick, concise, easy transfer of property where the initial owner, the original owner, has flexibility to change the beneficiary during his or her lifetime, and yet when that person dies, there are no probate costs and there are no attorney's fees. So it is a very significant savings, and one that will carry great benefit to the citizens of the Commonwealth of Pennsylvania. So in that respect, I would ask for your support. Thank you.
Thank you, Representatives. Council, anything to add? Yes, Council.
Thank you, Mr. Chairman. House Bill 2124 by Representative Bonner and Chairman Briggs establishes the Uniform Real Property Transfer on Death Act, providing a non-exclusive option for the transfer of real property after the owner or transferor passes. That occurs outside of probate. To be valid, a transfer on death deed or TOD must contain all essential elements and formalities of a deed, state that the transfer is to occur at the transferor's death, and be acknowledged and properly recorded prior to the owner's death. The owner or transferor must have the same capacity as is required to make a will, though a TOD is a non-testamentary instrument. Neither notice, delivery, acceptance, nor consideration are required to effectuate a TOD. To be effective, any instrument revoking a TOD must be acknowledged and recorded before the transferor's death, and it must be another deed, including another TOD, that revokes the prior deed in full or in part, either expressly or impliedly, or be another instrument of revocation. TODs made by joint owners can be revoked only if all living joint owners revoke. A beneficiary may at any time disclaim all or part of their interest in the property to be transferred in a TOD, in which case the property interest will be deemed to have lapsed. On the owner's death, the property is transferred. It is and will be subject to all conveyances, encumbrances, assignments, contracts, mortgages, and liens, or other interests which the property is subject to at the time of the death, but it will pass without covenant or warranty, provided that the designated beneficiary or beneficiaries survive the owner. Any property transferred by a TOD is exempt from state and local realty transfer tax, and no lender shall exercise a due on sale clause. If an owner is a joint owner who dies and is survived by one or more other joint owners, the property that is subject to the TOD belongs to the surviving joint owner or owners with right of survivorship. The interest of any beneficiary who predeceases the owner lapses. If all beneficiaries predecease the owner, the property will pass with the owner's estate. If all owners and beneficiaries die simultaneously, the property to be transferred will vest in the estates of the designated beneficiaries. There are provisions for if the owner and designated beneficiary are married to each other at the time that the TOD is made, any subsequent divorce proceeding divorce proceeding are subsequently initiated. Any unrevoked TOD shall be treated as a bequest in the owner's will and be subject to Section 2507 relating to the modification of circumstances. Property transferred under a TOD shall be considered as part of a transferor's probate estate for the purpose of a spouse's surviving right to an elective share. To the extent a transferor's probate estate is insufficient to satisfy an allowed claim against the estate or a statutory allowance to a surviving spouse, the estate may enforce liability against the property transferred by the TOD. Any proceeding to enforce liability must be commenced no later than 18 months after the transferor's death. And finally, Mr. Chairman, the slayer or and elder abuse statutes apply. This bill takes effect in 180 days, and there are no amendments. Thank you, Mr. Chairman.
Great, thank you very much, Council. I've called up House Bill 2124. The question is, will the committee report the bill, House Bill 2124? Are there any comments on the bill? Representative, you are in order on the bill. Representative Kuzma, you're in order.
Good morning, everyone, and thank you, Mr. Chairman, for bringing this up. I am an estate planning attorney by trade, and I would have to say that a transfer on death deed coming to Pennsylvania would be a phenomenal idea. Virtually every other asset that you could think of can have a named beneficiary on it. Any checking account, any savings account, any brokerage account, retirement, pension, life insurance, you can name a child as a beneficiary. Upon your death, they present a death certificate to the entity, and the asset is transferred over. I have a law firm back in my district that does estates and trusts. We do probably 300 wills a year and probably 50 to 100 estates a year. And I would say half of the estates would not have to be administered if this bill were enacted, because the majority of people, especially in Allegheny County and Washington County, their biggest asset is their home. And the problem with probate is, as Representative Bonner mentioned earlier, not just the cost associated with filing fees, legal, advertising, and the like, but also creditors and the length of probate. If you pass away in the state of Pennsylvania with any type of debt, medical, credit card, any debt whatsoever, a creditor has 1 year to file a claim against your estate from the time that it's advertised in a newspaper and a legal journal. So there are many times whenever estates can take longer than a year, and there are children that don't receive their inheritance for over a year. In addition to that, our Department of Revenue can take up to 6 months to process an inheritance tax return. And most estate planning attorneys do not want to administer the estate and distribute the estate until the inheritance tax return is approved by our Department of Revenue. So for those two reasons, people come to my office all the time trying to avoid probate. But we are limited in this state on the ways that we're able to avoid it. People come to me and ask all the time if they could add their children to the deed with them, okay? That is an absolute nightmare for our constituents, because whenever you add children or any other person to the deed with you, you are liable, and your asset is liable in the event that they file bankruptcy, they get a divorce, they get a judgment against them, heaven forbid they run over someone in the street. Your main asset, your house, is on the line. In addition to the liability, whenever you gift someone part of a property, whenever you add them to the deed with you and they don't live there, you are subjecting them to capital gains tax, which could be 5 to 10 times more than the inheritance tax. So that's one option. The other option is you can gift your property outright for $1 to your children. And when you do that, there is nothing to stop them from evicting you from your own home, okay? The third option is you could put your house in a trust, and the trusts are very popular in my part of the state. The issue with trusts is some law firms, not mine, charge in excess of $10,000 for a trust. And whenever you have, people on a fixed income with a humble inheritance, they don't have the ability to shell out $10,000. So by making it uniform and allowing an asset to have a beneficiary extend to real estate is a really good idea. And I think it's an excellent tool in the toolbox for estate planning attorneys and those that are worried about transferring their assets upon death. It's not ideal. It's not perfect. I'm not saying that everybody should do it because it doesn't avoid the inheritance tax issue, but I think it's nice to have another tool and another option for the residents of Pennsylvania, so I'll be in support of the bill.
Great. Thank you very much, Representative. Any other comments on the bill, House Bill 2124? I just want to thank Representative Bonner for working with Community Legal Services. They really are a great partner on a lot of work that we do here. Uniform Law Commission really has championed this. It's also supported by AARP, the Senior Law Center, Affordable Housing Centers of Pennsylvania, and the Urban League. If you, I don't know if you mentioned it, I think you did. It was definitely in the budget material. The governor has advocated for this to be passed in tandem with his budget proposal. So I strongly support it. Great bill to address generational wealth and hopefully help relieve some of the tangled title issues in Philadelphia. Is there any before we I'm calling this up for a vote, any negative votes on it? Seeing none, if the secretary could report it as unanimously passing and sent to the floor. No further comments, nothing else on the agenda. This meeting stands adjourned.